She did smash her phone in frustration during that meeting.
Look, to put it bluntly, this is about as lame an advice as you could get, isn't it?
So what you said there, to your knowledge at the time, was false.
To my personal view, yes.
Minister Roberts said, legal advice is just advice.
This is a summary of Week 8 of the Royal Commission into Robodebt. If you haven't seen the previous episodes, then it's best to start from the beginning. I'll link to Week 1 in the description. The Royal Commission publishes these hearings on their website, and Week 8 had around 30 hours of footage. I've cut that down so that you can still be across the key evidence. So this is Week 8. There's going to be a ton of witnesses I'm keen to hear from, like Stuart Robert. But first, let's go back to January 2017. The main players at the Department of Human Services were on leave, so a bunch of people were in acting roles temporarily. This meant that when media reports started dropping about Robodebt, these new people found themselves looking into the legality of the scheme, and what they saw concerned them.
Mr. Gladman, would you please inform the Commission of your full name?
Mark Stanley Gladman.
From December 2016 to January 2017, you held the role of Acting General Counsel Program Advice and Privacy Branch.
Correct.
For about a period of 4 weeks.
About 4 weeks, yes.
In January 2017, this witness was asked to draft legal advice about Robodebt. As he looked into it, he wasn't convinced that the scheme was lawful.
I felt that we were trying to, in the first instance, identify arguments that would support what the department and the government was doing. So at that point in time, I didn't feel that I could reach the conclusion that there were reasonable arguments to support income averaging.
Right.
His advice was that Social Security law was complex and that the department should get external legal advice. He recommended they engage the Australian Government Solicitor, or AGS, and started drafting instructions.
Are they the draft instructions to AGS as they stood at 10 January 2017 at 5:27 p.m?
I believe they would be the beginning of some material for AGS.
Okay. How quickly could instructions have been conveyed to the AGS following this email to retain them?
Very quickly. Well, I think we could have sent over the one that I typed up that said, "Dear Leo," the one that was about a paragraph. We could have started with that because that indicated that further material would follow.
I see.
He gave all this material to his boss, Lisa Carmody, but external lawyers never ended up being engaged. Let's hear from Lisa Carmody.
Ms. Carmody, could you please inform us your full name?
Thank you. Lisa Marie Carmody.
Also in January 2017, this witness was acting in the role of Chief Counsel for DHS, which is the department's most senior legal position. The usual position holder, Annette Musolino, was on leave. We've heard from Annette before, and she'll appear again in this video. This witness updated the draft advice that the previous witness had provided. The new advice was much more supportive of Robodebt.
Well, you've kept some bits of Mr. Gladman's advice and added others of your own.
Yes.
And if you go to the second page, one of the bits you added was an argument that perhaps it was reasonable and efficient to proceed on the best evidence or information that it has, for the department to proceed on the best evidence or information that it has available. But the whole thrust of this is, as long as the customer has the chance to comment, that's good enough, not that the customer must have commented. This is about averaging, not about getting a response from the customer and using it.
At that stage, when I was involved in the matter, our understanding was that the customer would be contacted to comment.
Sure. And if the customer doesn't respond, the department would use averaging to raise a debt. And what you were saying here is, that's fine if that's the best available information. without any regard to whether it's actually probative. And I wonder how a lawyer could say that.
I'm not sure that I have anything else I can add to it.
Well, the other thing that's notable in the advice is there's not a single section of the Social Security Act pointed to justify the use of averaging.
No.
Look, to put it bluntly, this is about as lame an advice as you could get, isn't it? And do you agree with that? As a legal advice, it's really unconvincing.
I agree that it's unconvincing. I think it was a note prepared as a wrap-up of some thoughts at the time.
It seems that this witness provided this updated advice to her boss, Sue Kruse. Interestingly, only a hard copy was provided.
It says at the top, there's some words in red at the top.
Yes.
The first set of words at the top in red are draft only.
Yes.
So may we take it that this was never provided in final?
Not to my knowledge.
Okay. But then the next words are hard copy delivered to Sue Kruse, 13 January 2017. Do you see that?
I do.
And paragraph 44 of your statement, you indicate that this seems to indicate that you did provide this document to Ms Kruse on the 13th of January 2017, correct?
I believe my note to be correct, Commissioner, yes. I can't picture myself in the location where I can say with certainty that I recall handing it to Ms Kruse or to anyone in her office.
The witness also said she told Sue Kruse that they should get external legal advice, for which instructions had already started to be drafted.
Given, as you've acknowledged, Ms Carmody, that the arguments that were able to be developed by that stage were unconvincing, wasn't it absolutely clear that the prudent and sensible course would be to get external advice on the lawfulness of averaging?
That was clear to me.
But just to be absolutely clear, that you think you would have made clear to Ms Kruse that the prudent and sensible course was to get external advice from AGS.
I don't know whether I will have used those words, but I think I will have made clear to Ms Kruse that I had contacted AGS and that we had prepared the averaging advice with references to that in it.
We'll now hear from Sue Kruse. But for context, there's emails showing that it was actually Sue who wanted this advice prepared in the first place, and as a top priority.
I call Sue Kruse. Ms Kruse, would you please tell the Commission your full name?
Susan Margaret Kruse.
Between the 23rd of December 2016 and the 16th of January 2017, you held the position of Acting Deputy Secretary Enabling Services.
That's correct.
The substantive holder of that position at that time was a Mr Jonathan Hudson, correct?
Correct.
Who was he on leave at the time?
Yes, he was on annual leave.
Okay.
This witness didn't seem to remember getting anything from Lisa Carmody.
I'll start that again. Do you have a recollection at all of Ms Carmody indicating to you that there was uncertainty as to the lawfulness of averaging?
No, I do not.
Or that the arguments in support of it were unconvincing?
No, I do not.
Or that the Legal Services Division recommended getting external advice from the Australian Government Solicitor?
No, I do not.
And that, in fact, steps had already been taken to confirm the availability of a lawyer at the Australian Government Solicitor to provide that advice?
I was not aware of that was occurring.
That you did not see or receive any draft or final version of this advice?
That's correct, to the best of my knowledge.
Okay. Do you agree with me that there is a notation on the document indicating it was delivered in hard copy to you on the 13th of January 2017?
I do.
And the evidence from Ms Carmody is those words were words that she added to the document. Okay?
Okay.
To accept, therefore, that this document in this form was provided to you in hard copy on the 13th of January 2017?
I don't recall that occurring.
Well, you might
I mean, it says it was delivered to me. I'm not saying it wasn't. I'm just saying I don't recall receiving it.
It seems a bit extraordinary, Ms Kruse, given the circumstances that we've discussed, that you've got no recollection at all of receipt of this draft advice document. Do you have any comment on that?
No, I haven't. I mean, I don't recall it. I'm sorry, I don't have a recollection of it. I wish I did. I don't.
Given the surrounding circumstances, surely you must have some recollection.
I have absolutely no recollection of it whatsoever. I recall over that period of time a lot of advice being coming backwards and forwards around addresses and letters and making sure letters were going to the right people. I recall multitude of media requests. I do not recall at any stage anybody coming to me and saying there was a concern with the averaging within the department coming to me.
Soon after, people started coming back from leave, like Catherine Campbell and Annette Musolino, and the work on figuring out whether Robodebt was lawful stopped. The next two witnesses were advisors to Alan Tudge, who was the Minister for Human Services in 2017. They basically said that it wasn't the role of their office to check if Robodebt was lawful, and that they took the department's word that it was a long-standing practice. Not surprising given the fact that Alan Tudge did nothing to address the scheme's legality when he was Minister. But this next witness is a huge piece of the puzzle. She was the head of the Department of Human Services when Robodebt was in full flight, and up to the point where it was shut down.
Can you tell the Commission your full name, please?
Renee Leon.
And Ms Leon, you are currently the Vice-Chancellor of Charles Sturt University.
I am.
Ms Leon, you commenced as the Secretary for the Department of Human Services in October 2018, is that correct?
2017.
17, sorry. In terms of your professional qualifications, you hold a Bachelor of Arts and a Bachelor of Laws from the Australian National University.
Yes.
And a Master of Laws from the University of Cambridge.
Yes.
Which specialised in international law.
Yes.
She replaced Catherine Campbell, who went on to lead the Department of Social Services. The Minister at the time was Stuart, who we'll hear from later.
One of the observations or comments you make in your statements is that there was a tendency or an unstated practice to provide difficult advice to ministers orally.
Yes.
Can you elaborate on that? Was that always the case from the point at which you commenced as Secretary DHS?
I would have said that that was the case when I was the Secretary of Employment as well as when I was the Secretary of DHS, but it certainly became more and more pronounced in more recent years, and there was much more visible feelings that there were consequences for people if they were unhelpful to the government. So people became more anxious to be seen as compliant with ministers' expectations about how things would be done. But it had been, I think, a long-standing and undesirable practice for things that were problematic not to be written down. Sometimes we put them in writing, but in a euphemistic way. So instead of saying, this policy will cause significant hardship, you might be expected to say something more like, this policy will cause community concern. So that were the matter to come out under freedom of information at a later stage, the minister couldn't be accused of having turned a blind eye to the fact of significant hardship.
This is important, not only because of the implications it has on an independent public service, or lack thereof, but it's also important because we've seen plenty of former ministers give evidence that they were never told anything, and that Robodebt was the department's fault, not theirs. Now, when this witness started at the department, the chief counsel was Annette Musolino, and it doesn't seem like Annette passed on any of the internal legal concerns.
Do I understand the effect of your evidence to remain that at no stage did Ms Musolino ever communicate to you that she was aware of advice from within the department which raised at least a question about the legality of averaging?
That's correct.
In 2018, there was publicity around a matter that had been decided in the Administrative Appeals Tribunal, or the AAT. We've seen this case be referenced many times before, and it was decided by Professor Terry Carney, who correctly identified that Robodebt was unlawful. His role on the tribunal was terminated by the coalition government soon after, and we heard from him in my Week 5 video. Anyway, one of his cases was getting attention, and the secretary asked Annette Musolino whether the department had in fact made an error that she should be aware of.
The 2 points that you raised questions about are addressed by Ms Musolino in this email dated 6 March 2018. The first is the attachment of a copy of the decision, and the second relates to whether there was an error in the original decision, and an explanation from Ms Musolino why she was of the view that no error was made in the original decision to raise a debt.
That's right.
The explanation provided by Ms Musolino is set out there. Her conclusion was that the decision to raise a debt on the basis of averaging is defensible and reasonable.
Can I just ask, how did you find that reassuring? She said that in her view, averaging was defensible and reasonable. Did you not want to know if there was actually a provision of the Social Security Act that permitted it?
It wouldn't ordinarily be my practice, unless I was told there was a doubt or a concern, to get down into the details of the legislation. I don't think in my entire time as the Secretary of Human Services I ever had occasion to go and get the Social Security legislation, because it's not my role to do the job of Chief Counsel, in the same way as I didn't try to do the job of the head of IT.
No, but you were a lawyer, and a lawyer of some accomplishment. Just seeing that bald statement, it's defensible and reasonable, it didn't make you a little nervous that she wasn't really offering very much there? It wasn't a very legal opinion, was it?
I probably deferred to Ms Musolino's judgment about this, because she was very experienced in social welfare law and I was not. So I knew it was an area of law I knew hardly anything about.
Fast forward to February 2019, and two big things happened at around the same time. First, the Masterton federal court case was launched against the government, and the Ombudsman was getting ready to finalise their follow-up report into Robodebt.
You were advised by Mr French, then Acting Chief Counsel, that Ms Masterton commenced proceedings in the federal court which challenged the lawfulness of a debt raised against her under the scheme.
Yes.
The point had been reached, I suggest, where the question of lawfulness could no longer be sidestepped, if indeed it was sidestepped by the department, but had to be confronted.
Yes.
All right. And concurrently with that, your office received an advanced copy, as is the ordinary course, of a draft report by the Ombudsman on 22 February 2019.
Yes.
The Ombudsman, Mr Manthorpe, invited your comments in the ordinary course as a matter of procedural fairness in respect of the intended publication of the report.
Yes.
The Ombudsman raised the question of whether the legality of the program was not reasonably certain, or at least whether there was a question to be asked about its legality, and recommended that the department take steps to be transparent about its position on legality. This was a passage which you ultimately asked the Ombudsman to remove from the draft report.
Yes.
That is, in its final report. And you did so on the 8th of March, yes. Is that right?
Yes.
The assertion in respect of the topic of the legality of the scheme raised in the draft report is addressed by you partway down the page, commencing in relation to paragraph 4.5.
Yes.
The concern expressed at the bottom of the page after the assertion of the department having consistently maintained the legal basis for the EIC is sound was that the comments imply there is a doubt as to the legality of the EIC system, and comments made by the Ombudsman on this aspect will undoubtedly be cited in public commentary in circumstances where a court is yet to determine the matter. I think it is particularly undesirable to buy into the argument about legality when litigation is on foot, as comments from the Ombudsman as a significant part of the administrative law system may be considered to prejudging the outcome or may in fact prejudice the issue. And you conclude with your request for the draft passages to be removed. But it was not the case at this point that even though the department had consistently maintained publicly that the legal basis was sound, that there was no question about it. Would you agree with that?
I didn't know that my legal people by then had doubts about it.
So she got the Ombudsman to remove a section on legality from their report, saying she didn't think the federal court case presented any concerns to the department. But soon after, the department received external advice from the Australian government solicitor that said otherwise.
The email is from Mr. French to your office and others, including Ms. Musolino, Friday, 29 March 2019. The summary provided by him indicated that Ms. Masterton had good prospects of succeeding in a claim for relief on the basis of the apportioned PAYG data. Was this the first time you became aware that in fact there was merit to the criticisms about legality?
Yes.
Right. And that was because it was external advice from the AGS which you thought ought to have been obtained in the first place if it had not been?
Yes.
The Ombudsman's report was released, I think, the same day, perhaps an hour earlier or two. The report was under embargo at this point because it had not publicly been released, and the ordinary courtesy is that the Ombudsman does this prior to publication. Is it your understanding that that practice, provision of an embargoed report, permits those potentially affected by the report to provide an urgent response to the Ombudsman about something if it is of great concern?
Yes, or if the Ombudsman has said something that turns out to be factually inaccurate, we like to make sure that that hasn't occurred.
By this point, you appreciated that your advocacy to the Ombudsman to remove the proposed comments on legality was successful, and the Ombudsman had agreed to do so. And in the context of that request, you had represented that the legal position is not uncertain. All right.
I wouldn't have had that in the front of my mind on the day I received the AGS advice, however.
No, and you can anticipate my question. Why didn't you then, irrespective of the stage of the report, ensure that the Ombudsman was informed that there was a legal question and that the department was engaging with that question by taking various steps?
I don't think I turned my mind to the reply I had sent to the Ombudsman some weeks earlier on the day I received the AGS advice.
And so just like in their first report in 2017, the Ombudsman was pressured by the department to change their report and failed to identify issues of legality. What this witness should have done, while there was still time before the report went public, was to flag to the Ombudsman that there was a federal court case against Robodebt that external legal advice had said had good prospects of success. But she didn't. As a result of the federal court challenges, the department eventually ended up engaging with the Solicitor General to get their formal legal advice. Later in the year, in 2019, this advice came back and was clear that Robodebt was unlawful. But it seems flagging this with Stuart Robert, who was the minister at the time, wasn't as easy as it should have been.
In that context of briefing the government, you spoke to Minister Robert, I think on 29 October.
Yes.
That was a telephone call.
Yes.
Is this a file note that you made on 29 October 2019 of this conversation with the Minister?
Not a file note.
Sorry,
I would have
diary
recorded it with some greater precision if it was a file note, but I did keep a notebook which I primarily used just for aid memoirs of things I'd been tasked to do or things people had said that I had to pass on to someone else. But for a conversation of this significance, I tried to record what transpired in the conversation.
And prompted by your contemporaneous note, I interrupted you during your recounting of the conversation.
So I told him the thrust of the advice, effectively, that we now knew that we couldn't raise debts for income compliance based on averaging. And I said, the department, will have to take some action to respond to the advice and as well as to work up what the financial implications of it would be. And Minister Robert, I've put this in inverted commas because it was his direct words, so I wrote it at the time as a direct quote. Minister Robert said, "Legal advice is just advice." And I took it by that to mean that he didn't share my view, that advice from the Solicitor General had to be acted on, that we had to stop the program because we had advice that it was unlawful.
What about his tone? What can you recall of that?
If I can try to, he took it appropriately seriously, but his tone when he said that was along the lines of, well, Secretary, legal advice is just advice. It was I think that is a rendition of his tone, that it was, and I remember it because it was so shocking to me, I suppose.
This evidence is very similar to what Tim French said in the Week 7 video. He also recalled showing Stuart Robert legal advice about Robodebt.
When I went to see the Minister, I took a copy of the Prospects advice in Masterton and I spoke to it. And I raised with the Minister the concerns that advice raised about the lawfulness of the Robodebt scheme and the need for the Solicitor General's opinion.
What did he say in response?
That it's just an opinion until we get a judicial declaration from a court. An opinion's only an opinion. I believe it might have been this meeting where he said something like that.
Ultimately, this witness ended up shutting down Robodebt before government made that decision.
But in the period where we were taking the matter to government for decision, because discussions with ministers, not only my own, but the discussions that were being had with other ministerial officers and conveyed to me or my staff, suggested that some ministers wanted to see whether we could stop the process but not repay the debts, stop the process but not tell anyone, stop the process and only repay debts if people appealed. So there was a lot of suggestions going around that seemed to me to be inconsistent, likely to be inconsistent with my obligations to do the right thing and the lawful thing. And so I asked Mr. French to prepare advice both to me and then to prepare advice to the Minister to emphasise that not only did the government have obligations, but if they weren't minded to be moved by those, that the public service had obligations and the Secretary had obligations, that would mean we had to take action to stop the program.
And did it come to that?
Yes.
That is, you stopped the program?
I ended up having to stop the program in advance of a decision by the government to do so.
Not long after, Stuart Robert terminated Renee Leon's position as Secretary and replaced the Department of Human Services with Services Australia.
Mr Keenan, could you please inform the Commission of your full name?
Michael Fayette Keenan.
Thank you. Now, Mr Keenan, you were formerly a member of the House of Representatives?
Yes.
And formerly a Minister for the Department of Human Services?
Yes.
Over what period were you the Minister in that capacity?
December 2017 to May 2019.
Thank you.
This witness was the Minister for Human Services after Alan Tudge, but before Stuart Robert. And despite Robodebt being in full flight during his time, he didn't seem to understand much about the department's legal obligations.
All right, and people who didn't respond would have their income averaged, and they would have an interest charge, whether it was right or not.
Well, I mean, if people didn't engage with the process, that was a possible outcome, yes.
Okay, and why should they have engaged with the process?
Well, I thought it was legitimate for the government to, where discrepancies had been identified, to go back and ask the recipient to help us to resolve those discrepancies. And there was ample opportunity, I thought, for people to be able to do that, including getting the department to seek the information that was required to do so.
Did you understand that the department was not doing this under any form of notice? They were just, although they were saying to people, you should tell us, you need to tell us. These were not notices under the Social Security Act, so there was no actual legal reason for a person to tell the department anything.
No, I didn't understand that, Commissioner, no.
It's no surprise then that he didn't do much when confronted with criticism that Robodebt was unlawful.
If you look at the bottom of the page 2, the email from media for April 2018 says, subject, breaking news alert, The Guardian reports Centrelink Robodebt program accused of enforcing illegal debts. You see that?
I see that, yes.
Okay. Well, do you agree with me that it would appear that the article refers to an academic paper by someone who was formerly then the longest serving member of the AAT, who had identified that there was illegality in how debts were calculated under the Robodebt scheme by reason of the use of averaging. Do you agree with me on that?
Yes.
Do you have a recollection at about this time in 2018 of responding to this article in The Guardian by making inquiries of the department as to what, if any, legal advice it had to support its use of averaging in the Robodebt scheme?
No.
Can you assist us as to why you would not have done so?
Well, look, that generally wouldn't be my response to an article that's appeared in a publication. I mean, this would have been part of probably dozens of media articles that we would have been privy to on that particular occasion. I'd already formed a view based on the advice from my department that the scheme was operating lawfully because that's the unequivocal advice that I had. And I wouldn't seek to, I didn't consider somebody saying something in the media to be an equal source of advice.
Sure, but
This was an academic article, you appreciated, by an academic with experience on the AAT and a very long history in social security law. This is just the Guardian reporting on the academic article. So wouldn't the fact that it was an academic article by somebody with expertise in the area cause you to think twice?
Look, it didn't, Commissioner, and I mean, it's not unusual, I think, for academic publications to criticise various government decisions, and this one in particular didn't stand out to me. And ultimately, when it came to expertise in social security law, my expectation was that my department was the source of advice in relation to that.
I think you've referred on a number of occasions to things you were told by people in the department. Can you give us an indication of when you were told those things?
In terms of the... Sorry, can you be more specific?
The legal position.
The legal position?
Yes.
Well, I mean, whenever I interacted with the department, which was infrequent about this particular program, it's really in the initial briefing that I received about the program itself, and then I suppose incidentally in things like media talking points, which had been through the legal department where they confirmed that advice.
Well, that initial briefing was by Mr. Storen, correct?
Yes.
He was not a lawyer?
I'm not aware of his qualifications.
You were told nothing to indicate he was a lawyer, correct?
Look, it's not the first thing I would generally inquire about.
Okay. Did he explicitly go into whether or not there was any legal advice in existence?
Not that I recall.
So what was the assurance that he gave you that gave you the assurance that the position was legally sound?
Look, I think it was just a general assurance that the basis of the scheme was sound.
Right. But didn't descend at all into the lawfulness of averaging?
No, but that's not a conversation that I thought that I needed to have at the time based on the information that I'd received.
Because this article dealt specifically with the issue of the lawfulness of averaging. You agree?
Yes, I think we've established that.
Yes. So what specifically did you, at any stage, receive from the department by way of advice as to the lawfulness of averaging?
I don't believe I ever got specific advice around that specific issue. It was just advice generally about the scheme.
Right. And as the Minister accountable to Parliament for the lawfulness of its action, of the department's actions, you didn't think, in the face of this article, that it was necessary to ask the department for advice on the lawfulness of averaging?
No, I didn't. But as I said, I mean, I'd been given advice by my own department in relation to the scheme. I had great confidence in the way that advice was presented to me because I had confidence in the department. They had a very extensive apparatus, legal apparatus to deal with this. And I considered that to really be a very significant repository of information around social security law, which is quite a specialised field. Look, I also knew, Mr Scott, I mean, this program had been through a cabinet process where a significant legal lens is placed over it. And it just wasn't really conceivable to me that there would have been any recourse to be concerned about the legal underpinnings of the scheme.
And not only did he not satisfy himself that Robodebt was lawful, but in 2018 he approved a proposal that allowed departure prohibition orders to be applied against people with robodebts.
Do you agree with me that's an executive minute to you dealing with departure prohibition orders?
Yes.
And is a departure prohibition order what is described at paragraph 2 of the document under the heading Key Points? That is, a DPO is an order preventing individuals with a debt from leaving the country as an incentive to repay their debt to the Department of Human Services, the department?
Yes, I see that.
This is a brief that would seem to have been signed by you on the 29th of June 2018.
Yes.
And there's comments from you. Can you read into the record? It's your handwriting. I assume that's your handwriting?
Yes.
Okay. Can you read into the record what those words are in your hand?
We can go harder on this measure.
Can you assist us as to what that's a reference to? That is the words, we can go harder on this measure.
I thought that this was an opportunity for the department to go after people who had debts to the Commonwealth, sometimes significant debts, who at every stage of the process had refused to engage with us about repaying them.
What a great guy. This next witness was a photojournalist for a newspaper. and had a number of casual jobs over the years and a history of poor mental health.
Mr. Thompson, can you tell the Commission your full name, please?
Matthew Clark Thompson.
In 2018, he was sent Robodebt notices.
So ultimately, the effect of these notices is that you had debts in totalling a bit over $11,000 raised against you.
Yes.
Can you explain to the Commission your reaction to receiving these notices?
Complete shock. Everything, angry, hurt, the whole thing, to the point where I just had to put it aside and just not deal with it for a while. I can't remember how that might have been weeks or...
He spent years going back and forth with Centrelink, providing payslips and having his debt reassessed. Eventually, in 2020, the government cancelled all his debt that relied on income averaging.
Can you in broad terms describe how your experience with Robodebt has affected you?
I think I've said in my statement it's taken years off my life, in the sense that the anxiety that I have to manage, I had a heart attack as well, so it's had a massive effect.
Giving evidence at a Royal Commission can be a difficult experience for some. What's motivated you to come and share your experiences today?
I've been watching the Robodebt on the YouTube channel, and I don't really like to kick a man when he's down, but Scott Morrison's appearance, I was watching the whole thing, and that night I couldn't sleep. I was that furious and wound up, and because I've taken his photo sort of thing, so one hand I'm taking a photo of Scott Morrison and the other hand I'm taking a photograph of a single mum who's struggling with the Robodebt thing, and that's what drove me to make this submission.
Your name is Tracy Tozer?
Yes.
And you are currently employed by Services Australia?
Yes.
And you have been for quite some time?
Yes, I have.
And you certainly were employed there in January 2017?
Yes.
You received an advice from Mr Glyn Fiveash. I know that you're nodding, but it's being recorded, so you have to give a verbal response.
Yes, yeah.
Thank you.
This witness was only involved in Robodebt for a short period of time, but in that time, she came into possession of legal advice from the department's lawyers. Now, we'll hear more about this advice a bit later, but this was around January 2017, the same time that the first witness was asked for their advice. The one we're talking about here was more direct and said that Robodebt was unlawful. This witness received the copy and forwarded it on before moving on to a different role.
But it seems that for years you were aware that at least one legal advice in the department conveyed something contrary to what was being said publicly by the department about the legality of the scheme. Did that strike you as odd?
It's a large agency / department. There's a lot of work happening, a lot of deliverables happening. Yeah. I mean, I knew about the Robodebt, may have read some media about it, may have read, some, but not involved. I was not involved in it, so I just read it like another email or another media report.
And did it cross your mind when you read those criticisms or media reports about the scheme that the department was projecting publicly that it was very confident that the scheme was lawful and that it produced debts accurately?
I don't recall that. Yeah.
Did you at any time think that maybe you should discuss this with people more senior than you, that there were legal thoughts presented to you by Mr Fiveash which appeared to be inconsistent with what the department was projecting publicly?
No, I didn't see that as being my role. There was the legal branch, there was the online compliance branch looking at this. I wouldn't have thought about having that conversation. Not in my role.
Not in your role. Is there generally a sense that if you come across something in the course of your employment in the department which is outside your role, but appears to you to be a bit off, that you just leave it outside the bounds of your role and let it be dealt with by those whose direct responsibility that it is?
It depends what you see. Like, I would normally keep in my own area,
Yes.
and be responsible for looking at what I was delivering or in my branch or slash division. I would speak up to a national manager or a general manager if I had identified anything in our deliverable space, but not outside.
All right.
Yeah.
We now hear from Annette Musolino, who was the Chief Legal Counsel at the Department of Human Services between 2015 and 2019. She appeared in my Week 7 video, where we learnt that despite being the most senior lawyer in the department, she ignored the many warning signs that Robodebt was unlawful and failed to get proper legal advice. In early 2017, she returned from leave and asked her team whether anyone had legal advice about income averaging. One lawyer responded to her, forwarding the advice he'd written not long before. This is the advice the previous witness was referring to.
Do you agree with me that it's an email chain commencing with your email on the 23rd of January 2017, which is your request for any legal advices?
Yes.
And then you see a response from Mr. Fiveash, same date, attaching a document. And it says, "Hi Annette, I wrote an information piece for the strategic analysis section a couple of weeks ago, attached." See that?
Yes.
See, it's the email, would appear to be the email from Mr. Fiveash to someone called Tracy Tozer, dated the 11th of January 2017.
Yes.
Except that would appear to be a, albeit brief, email advice on the lawfulness of averaging.
Yes, it goes to that issue.
And particularly appears to indicate that income averaging for the purpose of calculating social security entitlement is not lawful.
Yes.
An advice that you received, it would seem, on the 23rd of January 2017.
I can see it went to my email, yes.
Well, it was in response to a specific request from you to the Legal Services Division.
Yes.
You must recall receiving this advice from Mr. Fiveash.
I don't recall receiving this advice.
Was it your evidence that you simply missed this email?
Well, it's not that I just missed this email. I wasn't reading these emails as they came in. As I said, a number of I received 13 emails in response on the 23rd of January. They had substantial attachments, and the process I put in place was for them to be printed and given to Mr. Stipnieks to consider. And at some later point, Mr. Stipnieks came back to me with an email telling me what advices had been identified as relevant and what had been provided to the Ombudsman, and it gave me some analysis as well.
That's convenient. She says she didn't see the email that was sent directly to her that said Robodebt was unlawful. The witness was also asked about an administrative law conference in mid-2017, where she was getting live email updates of what was being said by the keynote speaker, Peter Hanks. We've heard about this conference in previous weeks. We've also heard from Peter Hanks in my Week 7 video.
Now, would you agree with me that the document comprises a series of emails, mainly from Mr. Stipnieks to yourself, reporting on what had been said by Mr. Peter Hanks at the Australian Institute of Administrative Law in July 2017?
Yes.
You, of course, know who Mr. Hanks is, Ms. Musolino?
Yes.
That he is an eminent silk.
Yes.
Yes. Specialises in public law.
Yes.
Including administrative law.
Yes.
Happens to be the author of a well-known constitutional law textbook.
Yes.
Quite regularly instructed to appear on behalf of the Commonwealth? Yes?
Yes, I'd accept that.
You knew that?
Yes, I think I would have known that.
I suggest that an opinion from a silk with those credentials about the lawfulness of averaging as it was used in the scheme, particularly that it was unlawful, was a serious matter.
I did, yes.
Raised a serious question about the lawfulness of the scheme.
Yes.
After the conference, Peter Hanks published an article which echoed his criticisms. It seems that this witness didn't do much as a result of either the conference address or the subsequent article.
I believed at the time that the paper was being reviewed and that it was being reviewed by the right team and they would bring issues forward if they considered it appropriate.
Wasn't it your duty as Chief Counsel to proactively follow up with them on this particular matter?
Again, in hindsight, I should have done more. I should have been more alert to it. I was responding to issues as they arose. I thought I had controls in place that if issues or advice needed to be brought forward, it would be brought forward. Was there significant consideration of Mr Hanks' comments? I think there was. I do believe that Mr Stepniak's and his team considered it. Should I have contested their views or probed more? Yes, I should have. But this is what I did at the time, and that was based on my view at the time it was in hand and it was being looked at.
You said you rhetorically asked whether you should have contested their views, but did they express any views about this paper to you?
Well, they didn't express any views that it gave rise to a risk that we needed to undertake further legal advice or obtain or take any action. So they didn't bring that forward to me at the time. Should I followed it up? Yes, possibly I should have followed it up.
Well, my question wasn't whether they expressed any views of a particular kind. My question was, did they express any views at all about this paper to you?
Not that I recall. I don't recall anything coming back to me, and I didn't locate anything in my searches about them coming back to me. It may have been discussed in a meeting, but I couldn't find a record of that.
And given the summary of what he had said at the conference, wasn't it obviously essential that you follow up with Mr Stepniak and his team to ascertain what work had been done to analyse the paper of Mr Hanks?
I think I should have done that. I don't know if I did do that. I don't recall doing it, so I can't tell you that I definitely followed it up. But I agree that would have been the right thing to do. That would have been the prudent thing to do, yes.
Also in 2018, you became aware of articles by Professor Carney regarding averaging.
Yes.
You agree with me that he quite strongly argued in that article that averaging was unlawful?
Yes.
In response to another article by Terry Carney, her team prepared some dot points justifying the department's position. But this response had no reference to case law, no references to legislation, and no proper administrative law principles. Yet this witness was satisfied.
Did you critically analyse this document at all? That is, the document supplied by Mr Rosa, headed commentary on an article by Professor Terry Carney AO?
I read it. It sounded reasonable to me. Did I conduct my own research and analysis? No, I did not.
I asked you whether you critically analysed it.
Well, I read it. Did I critically analyse it? Well, critical analysis would have required me to ask more questions. Did I do that? No, I did not.
Well, wouldn't it at least require you to reflect on whether or not it addressed all relevant legal principles?
I'm not certain what I considered at the time. I know that I read it and I accepted it and accepted what it was saying. I don't know how closely I had read the article by Professor Carney at the time, but I accepted the advice that was given at the time.
I think that's a strong feature of almost all the in-house advice from DHS and DSS is the studious avoidance of the relevant provisions of the Social Security Act. Did that never strike you? You know, most lawyers go back to the Act, given that decisions need to be made pursuant to the Act. They go and see what the Act says. Just doesn't seem to happen.
Commissioner, in some of the advices that we obtained or that we retrieved when we were doing the scrape, some of them do refer to sections of the Act. These ones don't.
Provisions of the Act which deal with rate calculators and bases of entitlement.
It's hard for me to explain why that is. I agree with that observation. They tend to be more high level.
Because you would need to look, wouldn't you, at what the rate calculators say about calculating income. You'd need to look at the definition of ordinary income, and you would find that it was actual income earned, derived or received in a given fortnight.
Yes.
And nowhere in that would you find room for averaging in the absence of anything to show that it reflected actual income.
I think we stopped looking at that question. I just think we were, to my early evidence, I think we accepted that averaging was lawful. And
well, I don't know that you stopped looking at it. I don't know that you ever started.
I accept that.
Okay, thank you.
All of this was a complete failure to satisfy her obligations as the most senior lawyer of the department. And what comes to my mind is gross incompetence.
I call Mr. Robert.
Mr. Robert, will you take an oath or an affirmation?
I'll take an oath, Commissioner.
Thank you.
Please place your right hand on the Bible. Your response is, I do. Do you swear by Almighty God that the evidence you will give will be the truth, the whole truth, and nothing but the truth?
I do.
Yes, Mr. Scott.
Thank you, Commissioner. Mr. Robert, could you please tell the Commission your full name?
Stuart Roland Robert.
Thank you. You're presently a member of the House of Representatives, Mr. Robert?
I am.
For the period 29 May 2019 to 30 March 2021, you were the Minister for Government Services?
And the Minister for the NDIS, correct?
Thank you.
We finally hear from Stuart Robert, the Minister responsible for Robodebt, just as it was all falling apart. Stuart really wanted to make sure that public money wasn't wasted on social security recipients. Because public money is for politicians to waste. In 2018, he was exposed for having claimed tens of thousands of dollars in home internet expenses. He ended up paying back almost $40,000 that he had wrongly claimed. That's more than most Robodebts he was so keen to chase down. Anyway, soon after he became Minister for Human Services, he was in a deep dive meeting with the department where Robodebt was being discussed.
The deep dive session occurred on the 4th of July 2019.
That's correct.
And you say, paragraph 58, that you asked during this session whether there was any existing legal advice on the issue of use of ATO averaged income data, and you say that you were told no.
Correct.
And then you describe what your state of mind was having heard the presentation at paragraph 60 of your statement, which is, you say you then held a strong personal view that the sole use of ATO averaged income data was insufficient to raise a debt, but was unsure if the partial use of ATO averaged income data was sufficient to raise a debt. For that reason, you decided that the next step to progress the issue was to obtain legal advice.
Yes.
This is important. From July 2019, his view was that Robodebt was unlawful. But for now, there's the issue that a previous witness, Tim French, had a different recollection. Tim French had said that he had raised to Stuart the fact that AGS advice about a federal court challenge to Robodebt said that it had good prospects of success.
When I went to see the Minister, I took a copy of the prospects advice in Masterton and I spoke to it. And I raised with the Minister the concerns that that advice raised about the lawfulness of the Robodebt scheme and the need for the Solicitor General's opinion.
Your evidence is that you weren't informed of the existence of this advice at the deep dive session on 4 July 2019?
If I can take you back, Mr. Scott, if I may.
Sure.
This wasn't told to me by the Secretary on the 27th. It wasn't in the Blue Book. It wasn't in Brief 119, which covered all the legal aspects. It wasn't attached to, nor referred to, nor inferred of in Cabinet in Conference Brief 120. So on the 4th of July, what I'm hearing and seeing from you is that my department had an AGS brief, and they've now had it for 27th of March. Is that the date, sir?
Yes.
They've now had it for March, April, May, June. They've now had it for almost 100 days and have not informed me in writing in any way, shape or form. I do not recall this being briefed to me. I don't recall my department saying on the 4th of July, we have an AGS advice, because if we did, my actions would have been consistent with what I did on the 7th of November when the SG advice arrived. My department had had it for 7 or 8 weeks. I had it for 2 hours before I walked straight into the Prime Minister's office, unannounced, put it down and said, we need to stop this. That was my actions then. If I'd had a copy of this, or if someone had shown it to me, I'm not too sure if I or my staff would have got to the person first to take it from them.
I'm just going to put you the evidence of Mr French given to this commission as to what he said occurred at the 4th of July 2019 meeting, Mr Robert. He says that he brought with him a copy of the draft advice to the meeting, and he quoted directly from the advice at the meeting to raise verbally the need for a Solicitor General's opinion. So is it your evidence that you don't recall that occurring?
I don't, but of course, at the end of the meeting, my recollection is there was broad spread agreement we needed to get the Solicitor General opinion.
And he says that you said words to the effect to him that legal advice was really only an opinion until a court declares the law.
Well, again, I don't recall that, Mr Scott, but I again put it to the Commission. If I refer to the slides from the 4th of July, the ones where that errant page was, you know which page it's in, every deep dive a department has, they produce the slides for it. If you go to those slides, you'll find nothing about the AGS advice in it. Now, I don't recall it being briefed orally, but if the department had said, here is the AGS opinion, and it says that averaging is unlawful, I would have grabbed it and acted on it. More importantly, if I look at the PGPA Act, section 19(1)(b), I think, it makes it very clear that secretaries withholding information that is material from ministers is an offence under that Act. So if the secretary knew that that existed and had not told me, then that offence may well be in play.
Can I, just for completeness, put this to you?
Yes, ma'am.
What the secretary said was that she thought she or a staff member would have told you or your office of the AGS advice orally back in June 2019, about the time of the Masterton brief, I think, because they did not want to put it in a written brief. So can you comment on that?
I don't recall that, and respectfully, Commissioner, I dispute that. The whole point of Brief 120 is Cabinet in confidence, is that it's Cabinet in confidence. It can't be FOI'd, can't be shared, can't be leaked, can't be doing anything. It's the whole point of you have things in Cabinet deliberation. If the Secretary had a brief that made it clear that the entire premise of a $4.4 billion program that had been running for 2.5 years under her watch, at least 3.5 years for the government, that it was now unlawful, the fact that that would not be given to me in writing is simply unconscionable. And I've chosen my words carefully, ma'am. How could a brief like that not be given in writing?
Okay, I think you've answered the question. You dispute the evidence.
Yes, ma'am.
Okay, thank you.
He's saying that he wasn't advised in writing of the AGS advice, and he's really trying to throw all the blame on the public servants, especially the Secretary, Renee Leon. The evidence of the other witnesses is that they told him about the AGS advice orally because the practice was not to put things like that in writing. That practice makes it easy for ministers to deny knowledge, exactly like what's happening here. The Minister's response was that there was a brief 120, that was Cabinet in confidence, which is a classification that means it can't be released publicly. And so according to him, there wouldn't have been any issue in putting the matter in writing in that brief. But here's my problem with that argument. I have a copy of brief 120, despite it being marked Cabinet in confidence. To me, that undermines his entire argument. For the next few pieces of evidence, let's remember that regardless of the contradictions, Stuart admitted that after the deep dive meeting in July 2019, his view was that Robodebt was unlawful. But what he said publicly didn't reflect that at all.
Let's just identify it first. Do you agree with me that it's a transcript of an interview involving yourself and Laura Tingle on the ABC 7:30 program?
One doesn't tend to forget interviews with Laura Tyndall, Mr Scott.
So the question from Ms Tingle is, but the problem here is a more generic one about the Robodebt system, which is that people get assessments just saying you owe us X thousand dollars. It doesn't tell you when that debt may have been raised or what it relates to. Can you understand why people are perplexed and a bit angry about this?
In the last 4 or 5 years, the department has recovered $1.9 billion in overpayments, and we have a legal responsibility to do that. And of course, we cross-check it with the ATO, and if there's a discrepancy notice is raised. And that's the legal requirement we've got.
Do you accept, Mr Robert, that what you've said in response to that question from Ms Tingle is inconsistent with the state of mind you assert you held at the conclusion of the deep dive session on the 4th of July 2019?
Yes, I do.
Okay.
Keeping in mind, if I've got a personal opinion, my next step is to seek the appropriate advice. Until such time as that arrives, I remain a Cabinet Minister and am responsible for holding the Cabinet line, which is what I've done in the interview. Respectfully, Mr Scott, Ministers are required to defend the government's programs as part of Cabinet solidarity, regardless if they agree with them or not, as, by the way, is the public service. I've implemented many things that I passionately disagree with, but I'm still required as a minister to represent them and defend them. And that's what I've done here, regardless of my personal sense of belief.
Well, it's not just a question of personal sense of belief. On your state of mind that you assert existed from the 4th of July 2019, you had serious doubts about the lawfulness of this program.
My view was the sole use could not be sufficient. It just can't. Yes, not just misgivings, it couldn't possibly work.
Couldn't possibly work lawfully, do you mean?
Correct, what I would call sufficiently. But just because I have a reservation, respectfully, does not mean I'm going to go on Laura Tingle's program and say I think the government program is wrong.
Well, you might not do that, but you might not express the degree of confidence in the program that you purported to in this interview.
In every interview, government ministers are expected to show confidence in the agenda of the government. There is no other way that the Westminster system operates. Cabinet ministers can't go out and defend some parts of a government's program and be wishy-washy on others. That's just not how a government can operate, sir, respectfully. An interview with Mr Spears?
Yes, on the 31st of July 2019. Do you see the passage towards the bottom of the page? In 80% of the cases, the debt's been raised, and in 99.2% of the cases, the debt is correct. Well, your evidence was that you could not raise a debt based solely on averaging.
That was my belief, yes.
And in 90% of cases, that's exactly what was happening under the program, to your knowledge at the time.
Yes, that is correct.
So what you said there, to your knowledge at the time, was false.
To my personal view, yes, but I'm still a government minister and it's still a government program, and this was the approach that Cabinet has signed off on 3 or 4 years earlier and had been going on. And until such time as I'm not a lawyer, I've got a competent legal view. It is still just my opinion.
Doesn't mean you have to misrepresent the figures, though, and say 99.2% of cases produce an accurate debt.
That's the figures from the department, Commissioner.
You're saying they were the departmental figures, but you knew they couldn't be right.
I had a massive personal misgiving, yes, but I'm still a Cabinet Minister.
Yeah, but it doesn't compel you to say things that you don't believe to be true, surely. It's one thing to stick to the policy and say this is how we do it and we're confident in the program, but to actually give statistics which you couldn't have believed to be accurate is another thing, isn't it?
They were the numbers from the department based on the working approach to how the program was being run. They were the accepted figures by government to use. And as a dutiful Cabinet Minister, ma'am, that's what we do.
Misrepresent things to the Australian public.
I wouldn't respectfully put it that way, because until such time, Commissioner, as I've got the legal opinion, I could be wrong. The Solicitor General will determine the correct path, but until that time comes, I can't just give my personal opinion. I have got to continue to uphold the government policy.
This wasn't a matter of law, this was a matter of maths, really, and you could see that the maths could not be correct.
Well, the reason I used the extreme example, ma'am, to choose your words, of the $1 million was to try and stress test it. So in my view, the maths could not possibly add up.
Okay, thank you.
His justification for lying to the Australian public was that he was waiting for further legal advice, just to be sure that the system was unlawful. Now, had he paused Robodebt while he was waiting for that advice, then maybe the justification would be valid. But that's not what happened. For months and months, people kept getting fake and unlawful debts. You can also add to that the fact that other witnesses said that Stuart already knew that there was critical legal advice. But not only was he lying in interviews, but he also labelled the Robodebt class action lawsuit as a political stunt.
Do you agree with me that's a transcript of a doorstop you did on the 17th of September 2019?
Yes.
Do you agree with me that the doorstop that's being transcribed here is in reference to a class action that was being launched with an announcement involving Mr. Shorten?
Yes, my understanding is Gordon Legal had flown from from Melbourne to Canberra to do a press conference with Mr. Shorten just prior to question time.
Okay. And you open the doorstop by describing the class action as a political stunt?
I did. No case lodged, no papers, no plaintiffs. Flown to Canberra, Labor lawyers with Bill Shorten before question time, and in their press conference they said it was a legitimate political strategy. On the basis of that, I think stunt is probably the apt term.
This is the class action that the Commonwealth ultimately settled in the matter of Bregodett's?
That is correct.
On the basis that the Commonwealth ultimately conceded that averaging was unlawful?
That's right, on the basis of the Solicitor General advice I'd asked for on the 4th of July.
Okay.
It's probably not the best look to be labelling a class action as a stunt, when the case then ended with a $1.8 billion settlement, one of the biggest settlements in Australian history. Instead of point scoring, these politicians could have been looking into the issues that were being raised. Maybe things like Robodebt wouldn't have happened. The Commission then focused on the Solicitor General's advice.
Of course, you recognise this document, Mr. Robert, correct?
I do, because I took it with me to see the Prime Minister on the night of the 7th.
And your evidence is that your office was not provided that document until the 6th of November 2019?
That is correct. That's when it entered the office.
Is it your evidence that you weren't informed of the substance of it before that date?
I don't believe so. I note Ms. Leon saying that she put a phone call through to me on the 29th. I don't recall that.
That phone call he's referring to is when Renee Leon said she told him that the advice said Robodebt was unlawful and that the scheme would need to be shut down. I should mention that it's disputed whether he's the one that ordered the Solicitor General's advice. Instead, it seems that it was already being organised by the department.
Do you have a recollection of, on or about the 29th of October 2019, Ms. Leon informing you of matters to that effect?
I don't recall that. I didn't make a note in my diary. I'm a prolific diarist in that respect.
I have to put the final part of what she says.
Yes, sir.
To you. She says that you said words to the effect, legal advice is just advice.
Well, considering I'm the one who asked for it on the 4th of July, my staff chased it up. When it arrived, within hours, not 8 weeks that my department had, or my secretary had, within hours, I walked into the Prime Minister's office to put an end to it and asked for an urgent ERC meeting, which occurred the following week. So I think my actions go to my state of mind.
The Commission points to a brief that the department provided to Stuart on the back of the Solicitor General's advice. The wording in that brief is interesting because it supports evidence that Stuart Robert had said that advice is just advice until the court makes a declaration.
And do you agree with me it's a brief to you about the Solicitor General's advice? Paragraph 7 commences with, whilst noting that the opinion does not amount to a judicial declaration of law. Do you see that?
I do.
See, one view of the evidence, Mr. Robert, is that the department thought it necessary to identify those issues because the Secretary needed to convince you to end the program because the Secretary perceived a lack of support from you in respect of that course.
I completely reject that, Mr. Scott, strongest possible terms. I asked for the advice on the 4th of July. I wanted it. My department took months and months to get it to me, and when they had it, they ostensibly sat on it for 6 weeks to work through what to do, and then as soon as I got it, I demonstrated the seriousness by walking straight into the Prime Minister's office.
Anyway, we can skip forward in time a little more, and Stuart Robert confirms that on the 13th of November 2019, the government agreed that Robodebt was unlawful.
But the 13th of November is when the government decision was officially made.
So that's when the position was settled, the 13th.
The position was settled on the 13th.
But the very next day, he appeared at the National Press Club to do a speech.
National Press Club speech?
Yes, on the 14th of November 2019.
Mm-hmm.
Do you see there that the transcript reveals that there is a question from, at the bottom of the page from Mr. Karp of The Guardian? Refers to the Robodebt program and comments by former senior AAT member Mr. Carney that Robodebts are illegal because you can't calculate a debt based on estimates of income. And then you say, okay, I'll answer if you like. Almost 1 million Australians own $5 billion in debts, and Mr. Shorten made the point during the election campaign that no one gets a leave pass from that. So we have an absolute responsibility, including a legislative responsibility to collect debts. We have a responsibility to ensure that people who earn a fortnightly income, who receive a fortnightly payment, that payment is appropriate and that their income that they are reporting to the Commonwealth is actually real and tangible. So using averaging as the basis to say to a citizen there may be a debt, can you please engage with us, is entirely appropriate. The truthful response to the questions from the members of the press gallery at that point in time would have been to acknowledge that the government had reached the point where averaging was unlawful.
It may well be truthful, Mr. Scott, but I wasn't permitted to. So, if I may, the ERC made it very, very clear that any public announcement was to be agreed. I'm just reading my diary now. Announcement to agree with the Prime Minister, Treasurer, Minister for Finance and the Attorney General. I needed 4 senior ministers to agree with me before I said anything. So whilst I accept the contention that it had been resolved on the 13th, I did not have approval to make any statement. So I've answered Mr. Karp's question very, very carefully. Not to talk about the use of averaging.
But you've actually said that using averaging is entirely appropriate, and you could not have thought that for a minute, and you didn't need to say it.
With respect, Commissioner, if I may, I've said using averaging as the basis to say to a citizen, there may be a debt, please engage with us. At no point in this answer did I say use of averaging to crystallise the debt. I kept my words very tight because I knew the decision had been made. I knew I could not communicate anything about it. I'm asked a question, so I'm in a hell of a position now where I know what government's done, but I can't communicate it. So I've got to answer in no less a forum than the National Press Club in a way that says something and says nothing. It's a dreadful place for a minister to ever be in.
We heard from this witness early on in my Week 1 video.
Your name is Emma Kate McGuirk?
It is.
She's been brought back for more questioning because of some emails the Commission has since found. This is what she said previously.
What did you think they were doing then? Not averaging at all, or?
Well, at that point, so I was new to this, Ms Halbert was new to this. We were only relying on the few documents that we were able to put together.
So you didn't have any reason to think that averaging was being used to raise debts? Is that what you're saying? Until you discovered this in 2017?
And our understanding from those documents was that, yes.
Essentially, she had tried to say that income averaging was a new concept to her when she was at the Department of Social Services in 2017.
Did you give that evidence honestly?
Yes, I did. That was based on my review of all of the emails that I had searched, refreshing. I mean, I was basing it on the documents that I had seen. I didn't have a lot of independent recollection, and that evidence was based on the emails at that time I was aware of.
But she was actually at DHS before she was at DSS, and she had previously been involved with the Robodebt proposal.
This is the email sent by you on Friday, 1 May 2015, when you were working at DHS
Yes.
as a Director of Income Support Means Test. Particularly at point 4, you will see that the means by which it was proposed to apply the PAYG or ATO data, which comprised a PAYG summary, was to evenly distribute the PAYG data across all fortnights in the employment period. You see that?
Yes, I do.
So that email was sent 24 April 2015, and you were followed up on the 1st of May, and you provided your response, which referred to a meeting in these terms: as long as the customer is given the opportunity to correctly declare against each fortnight and apportionment is the last resort, we support what you are doing. Good luck. And you accept that even though you can't now recall that context or sending this email, the true state of affairs is that you did know in 2015 about the use of averaging as a last resort in terms of what was proposed at that point.
Yes.
Another previous minister, Marise Payne, was called back for more questions, but I didn't get anything valuable out of that.
Do you swear by Almighty God that the evidence you will give will be the truth, the whole truth, and nothing but the truth?
I do.
Yes, Mr. Scott. Thanks. Take a seat.
Thank you, Commissioner. Ms Collins, would you please inform the Commission of your full name?
Tenille Collins.
Ms Collins, are you presently an employee of Services Australia?
I am.
Department of Human Services, which is what Services Australia used to be known as, is an agency that you commenced your employment in 2001?
That's correct.
This witness was involved in the development and rollout of Robodebt and reported in to Jason Ryman, who we saw give evidence twice before. You may remember that Jason Ryman reported into Scott Britton, who in turn reported to Mark Withnell. Mark Withnell was a senior executive at DHS, and when he appeared at the Royal Commission, he was pretending that he didn't know that income averaging was a part of the process. Income averaging was the unlawful part, and his evidence wasn't convincing at all. This witness had more details about that.
From that point, that is March 2015 until early January 2017, did you have any occasion to have discussions with Mr Withnell about the process and that it would involve averaging?
I was involved in some meetings with Mr Withnell where we were walking through process, walking through what's called the detailed requirements document, which is used to inform ICT of what they need to build for the online solution. There were numerous conversations with Mr Withnell about the process.
And did those conversations include discussion about the fact the process would involve averaging?
Absolutely, it was core to it.
There was also a lot of evidence about the former Deputy Secretary of DHS Melissa Golightly. She was basically the top person championing Robodebt, and she died before the Royal Commission started. Numerous witnesses have detailed how she was an abusive person to work with, who was unable to accept criticism.
I'm a little interested in that paragraph. The last line of it is that you believed on several occasions between September 2016 and May 2017 that you'd lose your job, and Ms Golightly reinforced that on numerous occasions. Can you tell us a little more about that?
Ms Golightly was a very difficult person to work with. She told me on numerous occasions, usually when I was trying to elevate concerns or risks, that I was not a very good public servant and perhaps I should reassess my career choice. She did threaten me numerous times with, you'll be lucky if you have a job by the end of the week, code of conduct, various things.
What about taking that to the Secretary? Did you not think about that?
I have reflected on that a lot. I didn't make a complaint about Ms Golightly's behaviour at the time. It's something that I feel embarrassed about.
There's more about Golightly coming up shortly, but in the meantime, we learnt that this witness decided to turn off parts of Robodebt in December 2016.
You talk about from December 2016 having a conversation with Marise Savelli about the increasing public scrutiny of the system, including reports in the media of customers who had been contacted by debt collectors on Christmas Eve without any prior knowledge of the review or debt. And having formed the view that this was not fair, you decided to turn off the automatic assessment for customers who did not contact the agency. When you say you decided to turn off the automatic assessment for customers who did not contact the agency, what did you do in response to that decision?
The context of that decision was that we had been having increasing media, similar to the media article we looked at just recently together, where it was becoming quite apparent that the inclusion of non-current customers in the measure was having this effect that, because they weren't getting the original notice, they weren't at their address. The first that customers were hearing about this was a debt collector at their door. Mr Savelli was the national manager of the ICT team who was responsible for the online build, and they had been raising concerns for quite some time at the board. My recollection is that this conversation started with Mr Savelli expressing his frustrations to me, asking me for my help. I think we were both talking about how we couldn't understand why nobody was doing anything. He indicated to me during this conversation that his teams, unbeknownst to anybody else, had built in switches to the system so that various elements of the system could be turned off without turning off the whole system. And he indicated to me that what was called the Day 22 automation, so it's the automation that would kick in if a customer failed to respond and engage with the process, that could be switched off. So I told him to switch it off.
I see. And did he do so to your knowledge?
I believe he instructed his teams the same day to switch it off.
You refer in this paragraph of your statement to Ms Golightly becoming aware of this decision that you describe.
Yes.
Can you tell us what happened when she became aware?
So we didn't tell her right away because, as it turns out, Minister Tudge made the decision anyway in January. So it was in late March. I can't recall exactly what we were doing, but we were in a room together, myself and Miss Golightly. Miss McCann was there. I think Mr Withnell was there as well, and a few others who I can't recall, but we were having a conversation about the parliamentary inquiries and our submissions for that. and I believe we were doing talking points for the minister, and I had to own up to the decision because they were about to put incorrect information in the submission to the parliamentary inquiry. So I had to say it wasn't done on that date. I actually did it in December.
Okay. And what happened then?
Miss Golightly was furious. I might need a minute.
Certainly.
We could take the break if you like. Would that be a good thing? All right. We will come back at 2:45.
All rise. The Commission stands adjourned until 11:45.
All right then. Do you want to tell us what happened on that occasion?
When I confessed to switching the system off in the meeting, my recollection is that for about the next hour, Ms Golightly screamed at me irrationally is the only way I could describe it.
Okay.
I then had a subsequent meeting with her the following day. She called me to the South Atrium Room, level 2 of the Louisa Lawson building. I can remember it quite clearly because I had to walk quite a long way and I had a feeling of dread the entire time. In that meeting, she was relatively calm to start with. She did smash her phone in frustration during that meeting. And in that meeting, she also told me that I was not getting a further opportunity because I was annoying.
The next few witnesses worked at PwC when the department had engaged consultants to prepare a $1 million report about Robodebt. The report, which was very critical of the scheme, was never provided. We heard in my Week 6 video from a PwC partner, Shane West, and his evidence was a farce. The Commission is trying to understand who had said the report was no longer required. A word of warning, there must have been something in the water at PwC because these witnesses had a terrible memory.
Thank you. Can you tell the Commission your full name, please?
My full name is Frank Van Hagen.
Mr Van Hagen, you were employed at PwC in January or for all of 2017?
Yes, that is correct.
Okay. And you were involved in the team that was assigned to perform work for the Department of Human Services in respect of its online compliance program?
Yeah, that is correct.
You learned at that point when you returned, as you say in your statement, that the report had not been finalised and was no longer required to be delivered by the department.
That is correct.
What do you recall of finding that out?
I recall I had a conversation with, I believe, with Shane and or with Ty that day. I recall that it was mainly talking about other things. However, that came up briefly as well, in which it was shared with me that a report wasn't finalised and wasn't shared with the department.
And was it explained to you why that was the case?
It may have been, but I cannot recall that.
That's not very helpful. Maybe the person he's referencing might know more.
Your response is, I do. Do you solemnly declare and affirm that the evidence you will give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Yes, Mr Gregory?
Thank you, Commissioner. Your full name is Ty William Bowe?
Yes.
And your current occupation is?
I'm a partner at PricewaterhouseCoopers.
Was it unusual to not submit the final report in the circumstances where it had been worked on for months up to the very last stage of the draft?
I haven't been involved in another project where that has occurred.
Yet have not come across that before?
I haven't, no.
And it didn't strike you as odd then?
I'm sure it was odd to me at the time, yes.
But you can't now recall anything about it?
No.
In the context of the first occasion that you had in your career to that point not been asked to finalise a report in a consultancy process, and in the context where there was an ombudsman's in review, and in the context where Mr Bowden, a partner at PwC, wanted to know to what extent PwC was publicly associated with Robodebt, is it your evidence that you now can't recall why the final report wasn't provided?
Yes.
Only that either Mr Webber or Mr Webber through Mr West informed you that it wasn't the case on about 6 or 7 June 2017 and the final bill was submitted?
Yes.
Is that your honest response?
Beg your pardon?
Is that your honest response?
Yes.
That you have no recollection?
I have no recollection.
Of why it wasn't provided?
Yes.
Okay, maybe one last witness from PwC, the most senior partner involved, will have a recollection.
Your response is, I do. Do you swear by Almighty God that the evidence you will give will be the truth, the whole truth, and nothing but the truth?
I do.
Yes, Mr Webber.
Thank you, Commissioner. Mr Webber, can you tell the Commission your full name, please?
That's Terence Ronald Webber.
And in 2017, you were a partner of PwC who had contact with Ms Catherine Campbell, Secretary of the Department of Human Services.
That is correct.
And your contact with her led up to an engagement, a DHS engagement of PwC to conduct a review of the debt collection program they had at the time.
That is correct.
And the second dot point, final report awaiting response from Terry. And the email indicates that something to do with the final report required a response from you. What do you recall of the situation in respect of the delivery of the final report as at 6 and 7 June 2017?
I don't recall what transpired between the 6th and the 7th of June, but my belief was we wouldn't have issued an invoice unless the client was completely satisfied with the delivery of the services as per our work order.
Well, PwC was always of the understanding that a report was a key deliverable under the work order.
The work order states a report.
Yes. And the report, you've just seen it, was prepared after agreement with DHS to be delivered on or around Friday 2 June 2017. But you know that it was not delivered at all.
Yeah, I don't believe it was delivered.
Yes.
A presentation was delivered.
Well, that was much earlier than the 2nd of June. And is it the case that then PwC was informed by someone at DHS that that report was not required to be delivered before the final invoice was submitted?
I don't recall that.
You had a good working relationship with Catherine Campbell?
Yes, correct.
That is, there were occasions when you and her socialised at PwC-sponsored events?
That is correct.
I suggest it's likely, given your relationship with her, that if there was to be a variation to a key deliverable of the contract, that is the provision of the report, it would have come from Ms Campbell to you.
I couldn't, it could have come to a variety of people within the department, to a variety of people within PwC, or it could have come from Ms Campbell to myself, but I don't recall actually where it came from, if it did.
It's hard to believe that no one had a recollection. Let's now move on from PwC.
Mr. Sparks, you were formerly a lawyer employed by the Department of Human Services.
I was, yes.
You're now retired?
I'm now retired, yes.
Okay.
This witness gave legal advice within DHS about what to do with an AAT decision. This was one of the decisions by Terry Carney, which had said that Robodebt was unlawful.
The Tribunal decided to set aside the decision, that is the decision of the first instance decision maker, and recover an overpayment of debt of youth allowance in the amount of $7,452.76 for the period 8 July 2010 to 6 June 2012, and send it back to be redetermined in light of directions that no debt or debt component is able to be founded on extrapolations from Australian Tax Office records. You see that?
Yes.
The reference to extrapolations from Australian Tax Office records, would you agree, is a reference to the practice of averaging as it was being used in the Robodebt scheme?
That's correct.
A practice which, would you agree, the Tribunal had concluded was unlawful?
Yes.
What you say at paragraph 19 of your statement, Mr. Sparks, is that the decision did not address the situation if salary records were not obtainable. And are you meaning to say that those directions left open to the decision maker on the remittal of the Tribunal to average if salary records were not obtainable?
I think on a strict reading of the decision, no, it didn't. I think it was silent on that point.
Can I just understand your logic? You accept that averaging from ATO data per se is not acceptable under the Social Security Act, is not in conformance with the requirements. How does it improve matters that there's an absence of information from another source and inability to get information from another source? How does that change that basic premise?
Well, it certainly changed it for the AAT because the AAT was making decisions along the lines that, you know, if you can't get the information, as a last resort, you can average. And
on what logical basis could you say it, though? Can you see any logic to that? If it is not within the bounds of the Act to do it, how does it improve matters that there's been some difficulty getting other evidence?
Well, that didn't trouble the AAT in the previous decisions that I referred to in my statement. The AAT said on a number of occasions, if you can't get the evidence, then you can. The only basis on which you can raise the debt is using the taxation information and averaging.
And what legal principle underlies that, as far as you understand?
Whatever the legal principle was, obviously the Tribunal found one.
Did they ever enunciate one?
Yes, absolutely.
And what was that legal principle?
No, it was simply...
it seems like a good idea.
Maybe, that's right.
So if you don't know what the debt should be, you're entitled to make it up?
No.
Well, it's close to that, isn't it? Because averaging did not produce accurate.
No, but that was the approach
results.
the Tribunal was taking.
The witness is saying that other AAT decisions allowed income averaging, and so that was his precedent to thinking it was okay. The problem was that the AAT was jammed full of Liberal Party cronies who would support the government's agenda. Some of the people making these decisions had no legal qualifications or were plain incompetent. Unless you had a decision that explained the legal principles, like the ones written by Terry Carney, it wasn't anything to be relied upon. I did a deep dive series into the AAT, looking into this shameful saga, and I'll put a link in the description if you're interested.
Anyway, getting back to this decision, it clearly did not contemplate averaging being a permissible
No, it didn't.
of recovery. So, well, I'll leave it back to Mr. Scott.
Given that it did not contemplate that, Mr. Sparks, it's obvious, isn't it, that the direction which was given was unqualified. That is, that on the reconsideration of the decision, averaging was required not to be used, wasn't it?
Yes, I guess that's implicit in one, yes. No debt can be founded on extrapolations from Australian Tax Office records. Yes, I agree.
Now, do you agree with me that's an email chain, Mr. Sparks?
Yes, it is.
Agree with me this email is talking about the reconsideration of the matter that had been remitted in the decision of the AAT that we've been discussing?
Yeah, that's correct.
And the issue that's identified by Ms. Keary is that for one of the employers of the relevant recipient, they were out of business and information from them couldn't be obtained. Do you agree?
Yes.
And do you agree with me that your advice is that the reconsidered decision can be made using averaging?
Yes, but only after the compulsory powers of evidence gathering have been fully exhausted.
Contrary, as you agreed, with the express direction of the AAT.
Yes.
And if we go to the first page of the document, last four digits ending 0234, you'll agree with me, won't you, that the email at the bottom of the page indicates that your advice had been implemented. Can you explain why you gave advice as a senior and experienced lawyer within the department to act contrary to an express direction of the AAT, Mr. Sparks?
The Secretary has the power to vary a decision after a person has had a AAT first review.
All right, well, I'll ask you to go to tab 41 of your main bundle and I'll ask to be brought up on the screen section 126 of the Social Security Administration Act 1999, compilation date 19 May 2017.
Yes.
Is that the section you've just referred to in your answer just now?
I think that would be, yes.
And you say that gave the Secretary power on the reconsideration to act contrary to the direction of the AAT?
It gives the Secretary the power to make a new decision at any point in time with a sufficient reason to do so.
Doesn't subsection 1 make abundantly clear that power only exists in respect of a decision of an officer under the Social Security law?
Yes.
Which by reason of the AAT's decision no longer existed because it had been set aside?
Yes.
And so this provision clearly had no relevance at all.
The legislation, in my view, does support the view that the Secretary can make a new decision after the AAT first review has made a decision. And I can see no reason to resolve from that.
What's the point of the AAT having a power to make decisions if the Secretary can merrily change them at will?
Well...
perhaps I don't want an answer to that. Thank you. Don't worry about it.
The final witness worked at DHS during the Robodebt pilot program. He appeared under a pseudonym.
Now, Mr. Simpson, we're calling you. Will you take an oath for an affirmation?
An affirmation, please.
Your response is, I do. Do you solemnly declare and affirm that the evidence you will give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Take a seat.
Mr Simpson, you worked as a compliance officer at Services Australia between May 2015 and December 2015.
That's correct.
And during that time, you worked in one of the expansion sites of the rollout of what we now call the Robodebt scheme.
That's correct.
He soon saw there was major issues with the process and tried raising them, but with no success.
And what was the response when you raised those concerns, particularly about averaging?
The management, in their response to us when we raised these concerns, we were advised that we were not responsible for the policy and that it was not our role to be questioning the policy. It was our role to administer and to carry out the policy. I became very disillusioned with what we were doing, and it was completely incompatible with my personal values. And I reached that conclusion after attempting through the formal workplace arrangements to raise these concerns, because there's always going to be policies that we don't agree with and that we have to administer. It's part of the job. But the issue here for me was that it was so clear and obvious that what we were doing was just categorically wrong and morally bankrupt, that it was just incompatible with my values, and I had no interest in continuing to deliver that role. So after 2 months, in what had otherwise been a really fulfilling time for myself in human services and in Centrelink, after 2 months in Robodebt, I made the decision that it wasn't a cause that I could support, and I had no interest in supporting it, and it was frankly embarrassing that I was there and supporting that policy objective. So I sought outside employment. Every afternoon I was coming home and I was asking myself, can I do this for another week? Can I do this for another month? Can I do this for another 6 months? And I think part of that came with the recognition that the work we were doing had very real consequences. And the example I always give to people is I can specifically recall individuals who I made decisions against, who I had to make decisions against, and one of them being a single mother living in a caravan park with 3 children and raising a debt against her of $13,000 and effectively asking, how would you like to pay today? And it's the appreciation of those consequences and that these are people that we are dealing with. And to me, it's not clear that there was any consideration that there was a human element to what we were doing, either in respect of the clients or the employees who were delivering this role.
And that's the end of week 8. I hope you found that valuable, and we only have 1 more week of evidence to go through. Thank you for watching. These videos take a lot of work to put together, and if you feel like helping the channel grow, then please consider checking out my Patreon page. I'll put a link in the description.